Hey there, Legal Tea listeners. This is your host, Jenny Roselle. We are back to estate planning of the rich and famous, where we chat about celebrities and their estate planning. Today's episode is on Robin Williams, and I tell you, Robin Williams is one of my favorite actors. Or maybe it's just because I love the movie Mrs. Doubtfire. My husband Justin and I actually visited San Francisco, California a few years ago, and of course we had to do the touristy thing and find the Mrs. Doubtfire house. Alrighty, so let's dive in, shall we? Let's talk about Robin Williams, his life, and what happened estate-wise following his passing. Let's kick off things by chatting about Robin and his peeps. So according to his Wikipedia page, Robin married his first wife, Valerie, in June 1978, and together they had a son, Zachary Williams, who was born in 1983. A few years later, in 1988, Robin and Valerie divorced. And shortly after the divorce, Robin began a relationship with Zachary's nanny, Marcia, and the two ended up getting married in 1989. At the time of their marriage, Marcia was actually 6 months pregnant with Robin's child, who they ended up naming Zelda Williams. And a couple years later, the couple had a third child, Cody Williams, in 1991. Nearly a decade later, the couple divorced in 2010. In the following year, in 2011, Robin met and ended up marrying his third wife, Susan. Tragically, on August 11, 2014, Robin Williams passed away by suicide at the age of 63. Even though Robin had a former drug addiction and alcohol addiction, both drugs nor alcohol neither were discovered in his body at his passing. According to CNN, Robin's publicist, Mara Buxbaum, shared that Robin was experiencing severe depression before his death. Also, according to CNN, Robin's third wife, Susan, also shared that while it had not really been publicly revealed yet, Robin had been diagnosed with early-stage Parkinson's disease, with hints of Lewy body too. In fact, according to an essay written by Susan, she shared that Robin's condition was, quote, described by several doctors as among the worst pathologies they had seen. Following Robin's passing, it was discovered that he actually had an estate plan. So at least he had something, right? And in my 23 episodes so far, there have been quite a few where the person had no estate plan at all. So at least Robin doesn't fall into that category. According to an article by the law firm Trust Counsel, an estate planning firm in Florida, Robin had created a living trust, or perhaps a couple trusts, and that shortly after Robin and Susan married, Robin had amended the trust. At Robin's passing, the trust contained the following super specific wishes. First, Susan could continue to reside in their home in Tiburon, California. Second, the Napa Valley house and its contents were to go to his children. Third, the quote, furniture, furnishings, and some of the contents of the Tiburon house, end quote, to Susan. Fourth, all of Robin's, quote, clothing, jewelry, and personal photos taken prior to his marriage to Susan, end quote, as well as, quote, memorabilia and awards from the entertainment industry, end quote, to his children. And fifth, finally, the trust stated that the rest of the contents that were not specifically provided for in the Tiburon house was to go to Susan. So one would think that is nice and specific, right? Well, clearly it was not specific enough. According to the article by Trust Counsel, Susan ended up filing with the court to gain clarification on what some terms in the trust actually meant. For example, Susan argued that the word memorabilia should mean, quote, only specific items of personal property as it related to Robin's acting career, end quote. Furthermore, she claimed that the term jewelry should actually not include his collection of watches. So, reminder, the jewelry was supposed to go to his kids. So she's trying to say that the watches should not be going to the kids. There were a few other things that Susan wanted clarification on from the court that I won't bore you with. The takeaway here is that it was all about tangible personal property. You know, a lot of families and beneficiaries fight about money, right? This was primarily about tangible stuff. And on the surface, it looks like Robin put in significant thought about what went to who. Interestingly, a couple episodes back, Thanksgiving week episode, if you remember, we talked about blended families and how their planning can take a sharp left turn so fast. Well, here is yet another example of that, my friends, just with a celebrity involved. According to Trust Counsel's article, part of Robin's trust included a provision to have the trustee, or the manager of the trust, take a chunk of change to cover, quote, all costs related to the residence. So that's the Tiburon residence. And have the trustee cover the expenses for the Tiburon house that Susan had a right to reside in. And I believe I read somewhere that the trustees were Robin's estate planning attorney and accountant, so they were professionals serving in these roles. Anyway, part of Susan's claim was asking for the trustees to utilize trust funds to cover around $30,000 in renovations. The trust was super non-specific. All it said was, quote, all costs related to the residence. So are we talking about utilities, property taxes, upkeep, etc.? Or if Susan wants to make major renovations, did Robin intend to allow Susan to pull those strings? Who knows? We'll never know. But it was so non-specific that Susan had a leg to stand on to request court clarification. Ugh. According to an article written by a Goralka law firm in California, Robin's children, when responding to Susan's attempts for clarification of trust terms, stated that they were, quote, heartbroken that Susan had acted against their father's wishes by challenging the plans he so carefully made for his estate, end quote. An article written by Kevin Hunt in the Hartford Courant, the court seemed to not be having this baloney. And in fact, the judge, following Susan's petition, gave Susan and Robin's kids a whopping 2 months to figure crap out, or more eloquently, as Kevin writes, to resolve the disputes themselves. I feel like I read somewhere that things did end up in a settlement, so full-blown litigation at least didn't occur, probably thanks to that judge saying, y'all figure it out. What I particularly find interesting about Robin's estate following his passing is that Susan and Robin's kids were not fighting about money, right? So often people in my estate world fight over money, property like a house, but here it was solely over that tangible personal property. And of course, tangible property has a value, but it's not super often that estate litigation happens only because of tangible property. And that's what happened here. I have to wonder if the primary issue was that it was a blended family. Susan was not Robin's kids, his mom, and Susan keeping some of Robin's stuff may have rubbed the kids the wrong way. I suppose what I'm saying is that if Susan was the kids' biological mom, we may never have seen this fight happen. As I was in the middle of writing this episode, I'm not even kidding when I say in the middle of writing this episode, I actually, crazy enough, met with a prospective client. It was a blended family. Husband had 2 kids, not with his wife. Wife had 2 kids, not with the husband. And prior to our meeting, they sent over to one of my team members a laundry list of tangible personal property items they wanted included in their will to ensure there were no fights between the kids. I had to share that I had this podcast and that I was writing an episode on Robin Williams. and that his wife and his kids were all mad at each other and duking it out over this tangible personal property. The wife jokingly slapped the husband on the arm and said, "See?" It gave me a good laugh. Talk about ironic timing. As I shared with them, I have found that yes, as I've said already a couple times in this episode, many times families fight over money. That's a given. Money on the table brings out the weird in people. I think we all know that. But often when there are unique relationships, like in a blended family sometimes, and a death occurs, emotions are extra high already. Then when you have to start wondering, oh, is my stepmom going to keep dad's guns, dad's watches, dad's classic car? Like, what if she keeps them and gives them to her kids? The audacity. Then, let me tell you, it's no longer about the money. It's about making a point and, quote, being right and doing what dad would have wanted. That's when I start hearing those sentences start getting thrown around. So let's talk about how we can prevent this craziness, shall we? First, you should really spell things out specifically and intentionally, especially if you think there could be disagreements about tangible property. There are two ways that you can kind of spell it out. You can either incorporate the verbiage into your will or trust, meaning the provisions for the specific tangible personal property would be inside the will or the trust. Or you can have your will or trust reference a document like a memorandum of personal property, where you can have a freestanding document reference specific items to specific people. The latter honestly is easier to change and keep updated. The first option of putting things inside your will or trust would require you to update your actual will or trust document to make changes. Another tip along this spell it out topic is you could, if you want, let me try that again. If you want to help your executor or trustee, try spelling things out by taking pictures and making sure wherever your provisions go, whether in the document or something like a memorandum of personal property, have those provisions reference the pictures. I have several clients that have taken pictures of items and even given me a flash drive of the pictures as kind of a second backup. Second, if you take the route of doing the memorandum so you can kind of keep it updated a little easier, make sure your attorney has the latest version of the memorandum. That way, if after you pass away, the memorandum accidentally, or not accidentally at all, if you catch my drift, if it disappears, your attorney will have the latest version to provide to your executor or trustee. Lastly, it certainly does not hurt to have conversations about what goes to who with your beneficiaries once you figure out where things are going. I have to wonder if Robin Williams would have sat his wife Susan down and his kids down to say, okay, this is what I want to have happen. Maybe at that time, Susan and the kids could have clarified a few things that ultimately Susan involved the court to clarify on. Like the whole piece about whether watches equals jewelry. Maybe Susan would have asked Robin then and there, hey Robin, are you thinking the watches count as jewelry? And that could have been the end of that and kept things civil. So I'm always an advocate. I'm always an advocate for having conversations. As much as people don't want to talk about this estate stuff, I'll never understand why more people don't talk about it with their family, beneficiaries, etc. So take those tips however you want. Alrighty, let's wrap this episode up. Next week's topic is a cautionary tale, a real-life case I or my office have personally worked on. And during that episode, we're going to be chatting about a woman who, following the sudden passing of her husband, did something that will surprise everyone. It even surprised me and my office. So tune in next week to find out what happened. Until then, Legalty listeners, take care and be well.